Hello, I'm Juliana Dunham-Irving, Executive Secretary to the World Bank Group Sanction Board, and I'm speaking today with Justice Kate O'Regan, one of the 7 members of the Sanctions Board. The Sanctions Board is an independent deliberative body within the World Bank Group which issues final decisions in cases of alleged corruption, fraud, and other misconduct. Justice O'Regan has been with the Sanctions Board since 2012, approximately the last 6 years, and has agreed to share some reflections on her work with us today. Kate, thank you again for speaking with us today. Could I first ask you to talk a little bit about your work prior to joining the Sanctions Board and how your position on the board fit within your career as a jurist and educator?
Thanks very much, Juliana. So I served as a judge on the South African Constitutional Court from 1994 to 2009. That was the first bench of the South African Constitutional Court, which was appointed after the move to democracy in 1994. And so all the first judges were appointed by our esteemed former President Nelson Mandela. And that was an extraordinary honor for me, but also a very extraordinary thing to happen to me because I was appointed to the court at the age of 37. And of course, I served on it for 15 years. And the work that comes before the Constitutional Court is largely appellate work, largely to do with human rights, but also with constitutional structure. The scope of the South African Constitution is very broad compared to some older constitutions. So in its rights, it deals not only with civil and political rights, but also with economic and social rights, with rights to clean environment, to administrative justice, and it also deals with the powers of the other arms of government, the legislature and the executive, and cases that involve the other relationships between central government and the provinces. So although we're not a federal structure, there is an allocation of powers between central government and provinces, and the court deals with those issues as well. So those are quite different sorts of issues to the issues I've dealt with on the Sanctions Board. After my term of office finished in 2009, I began to serve as an ad hoc member of the Namibian Supreme Court, which also has a justiciable constitution. The role of the Namibian Supreme Court is in some ways similar to the role of the US Supreme Court. It deals not only with constitutional matters, but also with non-constitutional matters, and is the final court of appeal in Namibia. Since I've left the court as well, I've worked for the United Nations as chairperson, the inaugural chairperson of the Internal Justice Council, whose responsibility was to protect and promote the independence and accountability of the internal justice system within the United Nations, and in particular to identify suitable judges for appointment to the 2 key tribunals that deal with internal justice, the United Nations Disputes Tribunal and the United Nations Appeals Tribunal. And then probably one last thing, this is a long ramble across my career, is that I have served as the president of the International Monetary Fund Administrative Tribunal since 2011. And that, again, is an internal tribunal dealing with internal justice within the IMF and deals with complaints relating to staffing matters by and large. So working at the World Bank Sanctions Board has been different to all of those jobs, partly because of the nature of the work that the Sanctions Board undertakes. It deals with the question as to whether sanctions should be imposed upon contractors in particular in relation to sanctional practices they may have undertaken on bank-funded projects. So it is, in some senses, particularly concerned about corruption, collusion, and fraud. And its raison d'etre is the protection of the public funds for which the bank must be the guarantor and protector. And that is a very focused brief and a slightly different one to the work that I had done in other courts and tribunals. But it remains an adjudicative task, a task of determining the rights of the litigants before the Sanctions Board, and in that sense, it is similar.
Thank you. In your experience with the Sanctions Board, can you tell us, have there been any surprising lessons learned?
Well, almost every tribunal or court or job I've ever done, one learns an enormous amount, and it's been no different at the Sanctions Board. So some of the lessons are about thinking about how a new process should work, partly because I was involved both with the Constitutional Court when it was set up and at the Internal Justice Council. I've had a lot of experience with working with new institutions, but I suppose a little like Tolstoy might say, all new institutions are different. And so one always has to think about, one's thinking structurally about what's working in the institution, what's not working in the institution, and that's been very interesting, and I think I've learned a lot. And it's also made me reflect on the responsibilities of the protection of public funds and the extent to which a process like a sanctions process can assist with that. So I think that it's been a learning experience around the substance of the work. It was also interesting for me initially. I've been one of the members of the Sanctions Board who has served in the circumstances when the Sanctions Board was composed both of internal and external members, and now it is composed only of external members. I must say that in my experience working with internal members, I learned a lot from the internal members, some of whom were not lawyers. I've had a couple of experiences working on adjudicative panels with colleagues who are not lawyers, and it's always interesting and a learning experience because you realize how many things that you take as normal and obvious, which non-lawyers don't, and how many good questions they ask about why we do things the way we do. And I think I learned from the internal members of the Sanctions Board a lot about how the World Bank works, how its procurement processes work, which I think was very important to understand in order to be able to do the work of the Sanctions Board well.
And now, having heard numerous cases with your Sanctions Board colleagues over the last 6 years, what impact would you say the board has had on the World Bank Group's work and development goals, and what challenges has the board faced?
So obviously, without doing any serious empirical work, it would be difficult for me to answer the question as to what impact we've had. Perhaps it might be easier for me to answer what impact I hope we've had, which is that I do hope that the lessons learnt from the work that comes before the Sanctions Board in terms of procurement, of where problems lie in procurement, are lessons that are absorbed in the operational work of the bank on a daily basis. I know that's always hard. That's something we used to hope happened in the Constitutional Court with the Constitutional Court's work, that it would be influencing the way government went about its daily business and dealing with citizens. And of course, it's never a completely straightforward process. Learning and changing institutions through legal rules and adjudication is not a direct process. But I would hope that that would be helpful, in a sense, to the work of the bank, to get the insights that one gets, I think, from the adjudication process carried out in the sanctions process and before the board. What are the challenges? I think that the challenges are not only challenges for the bank, but as the world becomes more and more of a global economy, more and more of an interrelated world, I think the responsibility for international organizations becomes greater and greater. We need to have a well-functioning, a fair, and a trusted system of international organizations to ensure that the global world works well. And I think that is a challenge. I think that will always be a challenge. But I think the establishment of a program like the sanctions process is an indication of good faith on the part of the bank, a recognition that it needs to be, as it were, a role model and a global leader in how to deal with corruption, which I think is very valuable, and what we would hope from international organizations, that it may not be able to eradicate all forms of corruption and fraud. Seems to be something we have to realistically accept, but one would hope that there would be a slow, steady trajectory to ensuring that public funds that the bank has the capacity to disperse will be done in a way which will ensure that the public funds are used for the public purposes for which they are dedicated.
A final question, Kate. As you know, Sanctions Board members such as yourself have brought a diversity of backgrounds and experience to the table as you've considered the various allegations and arguments in Sanctions Board cases, the individual cases that have come before you. with the benefit of your experience, what qualities and what knowledge would you say have served you and your peers best in your role?
Well, the first thing I want to say is that I have been extraordinarily blessed to work on an extraordinary array of tribunals that are diverse. And I fundamentally believe in diversity on a tribunal. And I believe in it not just because it might look good in photographs and because it might build trust in the institution, the trust being an important part of diversity, but I believe in it because I think it has a functional value as well. I think it improves the quality of decision making. We learn to realize where our blind spots are, where our sense of this is just how things are done may not be correct, because people coming from different legal systems, from different backgrounds, might say to us, well, we do it differently. And it makes you go back sometimes to first principles, to think more deeply about what is the appropriate way for adjudication to take place. And so, as I say, I think a diverse panel is it's a blessing to serve on one, but I think it's really serves has really improves the quality of decision making in those panels. It doesn't always make it easy, because sometimes if you're on a panel with everybody who has exactly the same experience as you, you're all going to agree much more quickly. But that, I think, is likely to mean that you're going to perhaps err more often as well. And again, just to talk a little bit about gender issues, because of course when I started my career, there were very few women lawyers and there were certainly very few women judges, and in some ways I've been very fortunate to be on the curve, ride the curve in a kind of way of women taking their rightful place in the legal profession and in adjudicative tribunals across the legal profession. And I think that's one form of diversity which really has likely to improve decisions by making sure that we have a broad overview of how all human beings think about problems. So I've been fortunate on that. But I think that the kind of, if you are going to work on a diverse panel, which really is to address your question more directly, I think it's important that you have the capacity to recognize that sometimes you may be wrong, that you still have things to learn, that we all have things to learn, to be open to the project of learning and listening, and to be excited about the idea of that project, of working with people from different backgrounds, and to realize that it will be enormously rewarding. So that kind of personal attitude, I think, really is valuable for people who are going to work in this kind of work. I think beyond that, it's very useful to have people who've had experience as judges, because I think that quite a lot of the work of any adjudicative panel it draws on the experience of decision making that judges do. But I think it's useful too to have people who've had experience within the international organizations, much as we do have on the Sanctions Board. We have an array of experience. So I think a diversity of legal background and legal experience is really useful in composing a panel. And I think the most important thing is that people will be willing to recognize that this is an extraordinary privilege to be able to adjudicate in any matter, and at times a burden, but that doing so with a diverse group of colleagues is something which makes it both enjoyable and more likely that you will get the answers right if you really work hard at it in the deliberation process.
Kate, thank you so much for sitting down to speak with us and for your service and contributions on the Sanctions Board. We have thoroughly enjoyed working with you. It's been a pleasure, and we wish you the best for the future.
Well, thank you very much, Juliana. You know that I am extraordinarily in awe of you and your team and the wonderful work they do in the Secretariat. I said to them all individually last night that I really think that they are a team to be proud of. They bring a great level of commitment and ability and enthusiasm for the work that they do, and I think that's a great thing for the Sanctions Board going forward. For me, it's just been a privilege to have been part of this process. I've enjoyed it, and I feel confident that the Sanctions Board will continue going from strength to strength.
Thank you.